morning, everyone. My name is Suzanne Templin, and I coordinate the webinars for Houseman Johnson Insurance. I would like to welcome you to today's webinar titled OSHA's New Standard on Electronic Recording and Post-Accident Drug Testing, presented by Rick Barton. Today's webinar will run about 50 minutes. If there is time after the webinar, we will have a question and answer session. If you have a question during the webinar, feel free to type it into the chat feature, and Rick will address it during the Q&A portion. If we do run out of time, please continue to put the questions in the chat feature, and we will address it after the webinar. After the webinar is over, there will be a short survey we are hoping you can fill out for us. A note that this webinar has been certified for continuing education credits by the Society for Human Resources Management and the Human Resources Certification Institute. Details on those credits will be provided to you at the conclusion of this webinar. Also, please be aware that this webinar is being recorded and will be available for review on the webinar archives of our website. If you do not want to participate in a recorded webinar, you may want to close the application at this time. You will receive a follow-up email regarding the webinar from us tomorrow. I would now like to introduce you to a presenter for today's webinar, Rick Barton. Rick has over 20 years of experience in safety and risk control, working with clients in many industries including construction, mining, trucking, manufacturing, and hospitality. He specializes in assessing risk for the clients of Houseman Johnson Insurance to reduce loss potential. Through safety assessments and loss analysis, Rick develops solutions which include safety management techniques, training, and engineering. Additionally, he has been asked to speak at local and national safety conferences on topics such as how to manage safety on a job site and what it takes to be a safety leader. Rick is an authorized instructor of OSHA regulations, construction, and general industry regulations. He is an active member of the Wisconsin Transportation Business Association, Associated Builders and Contractors, and the Wisconsin chapter of the American Society of Safety Engineers, and the Association of General Contractors. He is also on the advisory board of the Safety Studies Department at the University of Wisconsin-Whitewater. He clearly has a wealth of knowledge on this topic, and we are very thankful that he could share some of his wisdom with us today. Welcome, Rick.
Good morning, everyone. Hope everyone's having a good Thursday before St. Patrick's Day. In preparation for all the injuries we're going to have on St. Patrick's Day, it'd probably be good that we speak about OSHA's new record-keeping standard and not only post-accident drug testing, but also the other caveats that are part of the new legislation. My goal is to have you out of here prior to the start of the NCAA tournament this morning, and that way we can all get our brackets into our individual pools and we can enjoy the rest of the day. So with that said, I just want to make a few brief comments before we get started. This standard has been in place for a few months now. It came out in 2016, and it had an effective date of December 1st of 2016. As you know, there are a lot of record-keeping standards that we must comply with, including keeping your 300 log current and up to date, keeping your 300A, posting it, making sure it's available for employees, and many other things. We won't be focusing on how to fill out a 300A and what's recordable and what's not recordable today. We're only going to be able to focus on, in the limited time we have, on the new standard on the electronic record keeping that will be coming out shortly, and some of the caveats that have come along with this standard as anti-retaliation issues are presented to us. So with that, I'd like to get started and talk a little bit about what's happening and what has happened. So the first thing that we have to think about is what's happening with OSHA. As we know, OSHA is under transition. The new director will be appointed shortly, and there may be some changes. At this point, the standard is in place, ready to go, is live, and ready to go with the rest of the requirements later this year, and I'll talk about those dates in the meantime. There's been talk in Washington that this this standard, it will be looked at, and some of it may or may not be what we're talking about today in the same manner and form. So with that said, the biggest things that are going to change are how you are going to have to submit some of your data to OSHA electronically. The second thing that is affecting many employers is the requirement to make sure that the employer's procedures for reporting injuries is reasonable. We'll talk about that in a little bit. We also have to, and should have done this by December 1st of 2016, inform employees of their rights to report injuries and how to report injuries. And the last thing, and probably the biggest area that we get many questions on, is the employer may not retaliate against employees for reporting injuries through either discipline, through post-accident drug and alcohol testing, or through incentives. So the big issue there is what is acceptable and what is not acceptable. And I will say right now, until we get litigation or get a few OSHA involved cases, we probably can't answer those 100%, but we can give you a pretty good idea of what's coming down the pipe. So, as of December 1st, 2016, we are now required to make sure that we have informed and have procedures in place for employees to report injuries. It's not that we didn't have to have them in the past, but now OSHA has emphasized this area. So do employers have provisions regarding employee injury reporting, specifically the requirements to inform employees they have a right to report those work-related injuries? In other words, do you have a policy and a procedure that is easy for an employee to submit an injury report or report an injury to their either supervisor or to the company? The big thing that we find from this is the company needs to make sure that they do not prohibit an employee from reporting injuries, and I'll talk a little bit more about that. So there's a prohibition from discharging or otherwise discriminating against employees for reporting work-related injuries. It may sound like that's pretty straightforward, but it gets into how is your disciplinary program working and how do you address late reports and other safety-related injury reports. So let's talk first about the record-keeping issue, the big area that is coming up for everyone. We've all probably got our 300 A's posted on in our facilities and in our organizations. And for every establishment that you have, the 300 A's should be posted from February 1st, obviously, until the end of April or May 1st. Now, in addition to posting that, by July 1st of this year, all companies with basically more than 20 employees will need to now file those 300 A's electronically with OSHA. What does that mean? That means that that form that you fill out, you post so employees can see that it's in a recognized or easily recognized area. Those will now have to be electronically submitted to OSHA so that they can review those and use those for future data collection. As you can see in the footnote, OSHA will post the data from the employer submissions on a publicly accessible website. Many employees have asked, or employers have asked, well, that's great, but there's a lot of confidential information. I'll get to that in just a second. The one thing I do want everyone to be aware of is the site to post these on has yet to be developed by OSHA. It's in the development stage as of yesterday. There is not a site that we can go and submit the 300 A's. My understanding is that this should be done in the near future. They're hoping to have it done in the next 30 to 60 days so that you have some time before the July 1st deadline. For those employees that have less than 20 employees, you are pretty much exempt from this. If you have less than 20 employees or are one of the employers in Appendix A of the record-keeping standard, you're also exempt from the 300A. For those of you that have more than 250 employees at an establishment, you will be required not only to submit your 300As, but next year, prior to July 1st, you will also have to submit your 300s and your 301s, which is basically your first report of injury. You can either use, in Wisconsin, the WCK-12, or you could use the OSHA 301 report. They both serve as the same purpose according to OSHA. Many people ask, well, what is required to submit when there's so much personal data on those reports? The one thing you want to keep in mind is that when you do submit your 300 logs next year, you will have to omit the employee's name. Obviously, we want to keep that confidential. And then on a 301 or your WCK-12 in Wisconsin, for those in other states, there are other work comp forms that would be perfectly acceptable. You would omit the employee name, the employee address, the name of the position, and finally, any treatment provided away from the work site. Again, looking at the confidentiality of those reports. Your 300A, there's nothing that is going to be admitted or not allowed because none of that information is confidential. So with that said, I just want to point out that many of us are probably in industries that require reporting. Basically, OSHA has said that all employers over 20 employees at an establishment must report, and then I have provided on the next slide here a list of those establishments in between 20 and 249 that must submit their 300As going forward. If you're under 20, obviously you do not have to do that, and obviously if you're in one of the exempt industries, you may not have to do this. This is not an inclusive list. It is a two-page list, but most companies fall under probably the first 5 or 6 categories, and then the other 20 to 30% of employers fall under the rest. So if you're in construction, manufacturing, wholesale, agriculture, things like that, you will be required to report if you have more than 20 employees at an establishment. Keep in mind they do look at establishment. I've had this question come up several times. I have an establishment with only 10 employees at it. I might run an operation in another city. Do I have to report those? According to this, you would not, because obviously it's only for establishments with 20 to 249 employees. So those would not be required to be reported. So that's something that you don't have to report to OSHA. You still have to do your 300 log if you're over 10 employees, and you have to do your 300A and post it in your workplace. So I hope that was clear. If not, obviously let me know through our question and answer session. So what does this really mean for us? It means that we're going to have to file these reports. OSHA is going to have this information. And as Dr. Michael said before he left, our new rule will nudge employers to prevent work injuries and to show investors, job seekers, customers, and the public that they operate safe, well-managed facilities. In other words, they believe that you will provide a safer workplace because your data will be publicly accessible. And many companies I've worked with are concerned about having their data publicly accessible. But right now, that's the law. Access to injury data will also help OSHA better target compliance assistance and enforcement resources and enable big data researchers to apply their skills and making workplaces safer. If you read between the lines, what this is saying is now they can focus on industries that may have higher incident rates and also target probably facilities that have higher than normal accidents and injuries. So that is something that is coming out of this. I believe that this will probably have some industries focused on a little bit more. We may get some target programs out of this. We'll see as we move forward. So that's a big part of this whole process. Some other things we have to think about under the OSHA's electronic record keeping rule is that what is reasonable? OSHA says you have to make reporting an injury reasonable, and it must be easy for an employee to report an injury. Does the procedure that you have for reporting an injury account for all work-related injuries over time? In other words, is your procedure reasonable? Procedures which require immediate reporting without accounting for potent potential latency, in other words, carpal tunnel, soft tissue injuries, basically illnesses, does that allow you enough time to report that injury? OSHA looks at the need to have your employees report injuries as important, but they also understand that it has to be done in a reasonable amount of time. So exposure and onset of some symptoms comes on over time, so they may report it after the onset, and therefore you might consider it late. OSHA considers that maybe reasonable. They really have not defined reasonable in a very good manner. If you read the preamble, which I'm sure everyone just loves reading preambles, you'll see that there is no definition to reasonable. Is the procedure so difficult and complicated, a reasonable employee would be discharged for late reporting or not reporting? In other words, do they have to go through so many levels of management to report an injury, or is it difficult for them to report to their supervisor in a reasonable amount of time? So that's another area that OSHA will be looking at when you form your policies on how to report injuries. This really comes into play with field personnel that may have difficulties reporting an injury, or where you have to report it to someone above your immediate supervisor. So keep those in mind as you develop your policies and you educate your employees on how to report injuries and the importance of reporting injuries early and quickly, so we can medically treat those injuries and illnesses. As we move on through this, I'm sure that OSHA will have their chance to review some of your policies and procedures, and at that time we'll have a better idea of what they consider reasonable as we proceed. Keep in mind, as of December 1st of last year, 2016, you should have informed your employees on how to report those workplace injuries. You can either use the poster that OSHA provides, and the number is provided up there. If you go on their website, you'll be able to find that, or you can, at a minimum, provide your employees with a written excerpt from that poster outlining what's in red in the slide. So we need to make sure we inform our employees. Hopefully everyone's done that as it was required by last year. If not, it's probably not a bad thing to put in one of your upcoming safety meetings or any way you communicate your safety information to your employees. The big thing is making sure employers have formally done this and there is documentation that we've informed our employees. So as we delve into this a little bit farther, we want to talk about three different things. We've talked about the fact that you do have to report your injuries electronically, and we have to make sure the employees know how to report an injury. But the big questions come in the next three areas. We'll end up talking about discrimination. OSHA basically wants to make sure that we are not retaliating against our employees for reporting injuries. And they consider retaliation possibly the use of disciplinary procedures inappropriately, maybe discriminating through drug testing and alcohol testing, and then finally discriminating for employees reporting or not reporting injuries because of an incentive that they may receive due to limited injuries. So with that said, the employers are prohibited from discharging or in any manner discriminating against employees for reporting work-related injuries, and that's a key issue. We look at the discrimination. OSHA now has the authority to come in and review your procedures, and they can now take a look at if you've been discriminating, and they can fine you under the OSHA Act, and they can also do a few additional things. So in other words, if you look at the bullet points underneath there, you'll see, according to OSHA, the following are just some examples of adverse action. If you discharge, demote, or deny substantial bonuses because someone did not report an injury. You assign the employee points for reporting injuries. So in other words, maybe you assign a point for a tardiness or an absence, but we also assign points that could lead to future considerations, whether that's a promotion or other issues. I would strongly encourage that anyone that works in this area and has questions on that, it might help to make sure that Human Resources is on board with your policies and procedures and that those are carefully outlined. Do you demean employees because they report an injury? In other words, do you embarrass them, make them stand out, post their names somewhere? That could be demeaning or embarrassing, and that may be discriminating. Do you threaten or penalize or otherwise discipline employees for just plain reporting? Again, you have to look very closely at that and make sure that your policies and procedures and your management staff are not doing these. Otherwise, we could have OSHA looking farther beyond the scope of just injuries and also how employees report those injuries. And then it also talks about taking a drug test. Could be demeaning. It could be not adequate if it is not a legitimate business reason. And I'll talk about that in a little bit more detail as we get into the program. So with that, we want to talk a little bit about what some of the points that OSHA has made that really, I think, come to point. The final rule allows OSHA to issue citations. We've already had 11C where they could come in and look at discrimination for adverse actions, but now they're allowing OSHA to issue citations to employers for retaliating against employees for reporting work-related injuries. So in other words, not only may we have an OSHA citation, but as you can see from the second large bullet point, the abatement that can be used in 11C, abatement that can be used even if there is an 11C has not been filed, we can still, through OSHA now, reinstate back payment or reinstate the employee and provide back payment. Excuse me, I misspoke there. So if you discipline an employee because they didn't report an injury or they reported an injury and it's very vague, you could also be cited. Obviously, we know the citations penalty structure has gone up. We also could be cited an OSHA citation upwards of $120,000 if it's willful, $24,000 to be exact, and we could also have back pay provided and reinstate that employee. So basically, OSHA says disciplining employees who report injuries late or disciplining for violations of vague work rules such as work carefully or maintain situational awareness could be brought into an OSHA citation. And I would be very careful to go back to your handbooks and your safety policies and make sure you don't have some of this vagueness in there. OSHA will look at that as you use these policies to enforce your safety rules. By no means are we asking anyone to get rid of disciplinary procedures, to get rid of incentive programs if they're structured right, or even get rid of drug and alcohol testing. It has to be set up properly to meet the requirements of the new OSHA regulations. With that said, the rule does not ban appropriate disciplinary programs. Basically what OSHA is saying is if you have one, you need to follow what you have in writing and make sure it's very consistent. Employers must ensure disciplinary measures are applied consistently to all employees, injured or non-injured. And I think that's an area where we often have to work very diligently on in order to make sure that we're properly enforcing our safety rules. On the next couple of pages, I'll share with you some examples. And one of those examples, taken right out of the OSHA preamble, this is not something that we made up here. This is something we took right out of the preamble, but it really goes to serve notice. And if an employer disciplines an employee for reporting a bee sting and states that the discipline is for maintaining that situational awareness and only disciplines when there is an injury, this would be a violation under the record-keeping standards, paragraph B1, Roman numeral 4. And that is something that we have to be very careful on. If we have verbiage in our handbooks, our policies on maintaining situational awareness or making sure that people are working carefully, we might want to reconsider those and deal with those and make sure they're correct for future use. On the other hand, another example that's provided, if you bypass a machine guard, contrary to your safety policy, even when the employee is not injured, he could be injured and you can discipline him, but even if he's not injured and we discipline him, this would not be a violation of the OSHA record-keeping standard. In other words, we have to follow consistent policies and procedures. We have to look at the hazard, and if we violate people for not following rules that we have already established, then we have to follow our disciplinary procedure. The big area that when we talk with the OSHA offices, they really focus on making sure your disciplinary program is consistent and it's enforced across the board, whether someone gets hurt or does not get hurt. If I'm not wearing my safety glasses as I walk through the facility, is that a safety violation under your policy, and is that enforced? If someone then gets hurt and they weren't wearing their safety glasses, it would be a lot easier to enforce this program. So we have to think about that and how we use it. So I would just encourage everyone to go back, look at their disciplinary procedures, make sure they're following them, and make sure that management and supervision understands that they have to be very consistent in order to follow the new OSHA record-keeping standard. The next area that comes into play are incentive programs. OSHA feels that incentive programs may deter employees from reporting injuries, just like a disciplinary program may deter an employee from reporting an injury. Because they report an injury, they may feel that they may get reprimanded for something that was completely out of their control. Same with incentives. If they report an injury and the incentive is discontinued, OSHA feels that they may not report the injury and it may deter them from reporting those injuries. So the incentive program cannot incentivize non or under-reporting. Programs based on lagging indicators as opposed to leading indicators are usually problematic. In other words, I incentivize people for my whole facility goes a month without an injury, we're going to bring in lunch for everyone. That's a lagging indicator. We're incentivizing somebody for doing something that happened in the past. OSHA is really focusing on trying to have you look at more leading indicators. OSHA also indicates determinations will be made on a case-by-case basis. Rule of thumb is you don't need to get rid of your incentive program. What you need to do is make sure that those incentive programs do not deter employees from reporting injuries. It goes back to step one. Do the employees know how to report injuries? Is there an easy method for them to report injuries? And then do we deter our employees from reporting injuries? And if we do, what is deterring them from reporting them? And is it maybe a disciplinary action that may happen to them? Is it an incentive they may lose? And if it is, we need to rethink how we institute those programs. So with that said, let's talk about incentive programs. One of the caveats that is in the standard, and it's a little vague right now, and there's been no interpretation on it, is OSHA says a substantial cash incentive is canceled when an employee reports an injury would be a violation of their record-keeping standard. The problem is we don't have any guidance on substantial. When I look at this, I may think that $50 is substantial, but another employee might say, I think $10 is substantial. So I think they have to give us better guidance on this. The big issue, I think, is I would probably encourage and push along the idea that maybe we need to remove incentives from the lack of injuries, but in other words, look at what's leading to the lack of injuries and those leading indicators. So as you can see an example 2. An employer announces a substantial cash drawing at the end of each month for each work group who follows applicable safety rules. Cancels it for the group when an employee who is not wearing fall protection falls and sustains a lost time injury. This is not a violation because they are not canceling it because of the injury, but rather because of the lack of following a stated safety rule of using fall protection. OSHA would accept that. Again, remember, whenever we deal with OSHA, we have to show them what we're doing that does not violate their standard. They have the burden of proof, I understand that, but we need to be showing them that we are doing what's in the best interest of our employees, and in this case, we have a safety incentive for that work group, and it is to follow the safety rules. The safety rules were not followed. That's why the incentive was canceled, not because of the injury that happened. That's the issue that we have to try to present, and I think it makes good sense. OSHA encourages incentives for employee participation in safety program activities, such as training, safety walkthroughs, and so forth and so on. When you look at all of these are really those leading indicators. Activities that are intended to promote a safe work environment and promote the reduction in injuries or help employees understand the safety hazards and therefore provide a safe workplace. So when you're devising your safety incentive programs, OSHA is not saying get rid of safety incentives. They're saying let's structure them so that they do not deter employees from reporting injuries. If I had a $1,000 incentive at the end of the month for a drawing, it might incentivize some people not to report injuries so they could continue to be eligible for that safety award, that $1,000. So again, I think it's important that we take a look at our safety incentive programs, make sure that they are set up so that we don't deter employees from reporting injuries. OSHA states the final rule, and this is probably the area, and I left it for the end for a reason. This is the area that we have many, many questions that still come up. It is an area that I don't know that it'll ever be black and white, but I think we can add a little more blackness and a little more whiteness to this as we get more case studies by OSHA, and obviously we have to see if the standard's going to hold. But OSHA states that the final rule prohibits employers from using drug testing or the threat of drug testing to retaliate against employees for reporting an injury. So in other words, an employee, many policies are blanket policies. They may state that any employee that gets injured and seeks medical attention will get drug tested. OSHA says blanket post-injury drug testing policies may deter employees from reporting those injuries. So now it gives us a chance to go back and look at our drug and alcohol policy and determine if our drug and alcohol policy could deter employees from reporting an injury. The premise is, OSHA's premise is a poorly designed and implemented post-accident, and again, the only part of the drug and alcohol testing program we're talking about is post-accident, policy may inhibit employees from reporting or punishing them for reporting, resulting in under-reporting. In other words, OSHA still feels that there's under-reporting done by many, many companies. And that's why this verbiage was put into the new record-keeping standard. And as you can see, under the record-keeping standard, it does not prohibit employees from drug testing employees who report, so as long as they've reasonably, or objectively and reasonably have a basis for that testing. The rule does not apply for testing employees for reasons other than injury reporting. So if you have pre-employment testing or you have random testing, those are not prohibited. It's only the post-accident testing. As we move through this section, think about your post-accident drug and alcohol testing, and think about how it's being used and what you're doing with it and the end result. I can just tell you that I've worked with several companies that are upping their random selection and may go away from post-accident drug testing. Some employers don't feel that's the right way to go. Again, that's a call on an individual company's basis. We can help you design those programs and help you with some of the language in there. But most importantly, we have to make sure that when you have a drug and alcohol testing program, it's consistent and it follows steps so that it does not deter employees from reporting injuries. As you can see, employers may conduct post-incident drug testing pursuant to state or federal law, including workers' compensation, drug-free workplace policies. Random employment testing is not done. This may be taken the wrong way. What this means is that if you're in a state that has a drug-free workplace policy, OSHA will not issue those citations if it's part of a state law or a federal law. As like I said earlier, pre-employment and random testing are not subject to this section. And so we have to think about that. What does that mean? If I am in a state that I have a drug-free workplace policy and maybe I provide, the insurance company provides a 5% reduction for having a drug-free workplace in your insurance premiums, OSHA says that's fine. You can do post-incident drug testing. And when I say drug, I mean drug and alcohol testing. However, many employers have asked, how does that pertain to the Wisconsin new statute where if I post-accident drug and alcohol test and someone tests positive and there's indemnity payments, those indemnity payments can be reduced or eliminated because of the use of drugs or alcohol. It's been basically stated to us that that does not apply. That is the state policy within the workers' compensation system. That does not apply to this standard, and OSHA will cite you for drug and alcohol testing if the injury could not have been contributed from drugs and alcohol. The second thing I want to point out where OSHA has also ruled is that collective bargaining agreements. So you might have a collective bargaining agreement that says you have the right to do drug and alcohol testing. That cannot supersede this. Your drug and alcohol testing has to be done only on accidents and injuries where drugs and alcohol could have played a role in that injury or illness. So those of you that have those collective bargaining agreements and you have post-accident drug testing, it's something that you're probably going to need to look at, and maybe when we come up to our collective bargaining times, we can restate those and use those accordingly. A couple examples that are provided to kind of give you some depth into this. One example on when and when we cannot do testing is an employee was injured when inadvertently driving a powered industrial truck into a piece of stationary equipment, reported it to the employer, and had to take a drug test. Because there's a reasonable anticipation that drugs or alcohol could have played a part in this incident, this is not a violation of this section because it is reasonable, as this conduct can be affected by drug and or alcohol use. So that's one example. Another example, and this is where OSHA I think is trying to steer us to, is we report an illness like carpal tunnel. Now, obviously we know carpal tunnel happens over a period of time. It just doesn't onset instantaneously. If drug use could not reasonably have been contributed to this illness or injury, the employer has no other reasonable basis for requiring a drug test, and this would be a violation of the record-keeping standard. So in other words, we need to go back and look at whether or not the drug and alcohol could have contributed to that injury or illness. And we need to make sure that we do have a reasonable basis for that testing. As we move on, another example that's been used around is the 5% reduction in premiums and work comp. I already explained this on a previous slide, but I want to make sure that everyone understands this is a one area that OSHA has ruled or put in their preamble, and basically said that this would not be a violation if it is pursuant to the work comp law. However, when asked about the Wisconsin state reduction or elimination of indemnity payments with the new state statute under a work comp law, that does not apply. And so we have to deal with that here in Wisconsin. As we move on, we also have to think about a few other things. OSHA's interpretation for drug and alcohol testing basically, and again, this is post-accident drug and alcohol testing, states that OSHA will only consider whether the drug test is capable of measuring impairment at the time of the injury or illness occurred where such a test is available. Therefore, at this time, OSHA will consider this factor for tests that measure alcohol use, but not tests that measure for other drugs. When they stated this, I think they meant that there's not many good tests out there that can diagnose a person as to whether or not other drugs are at a level that could cause impairment. There are some tests that can be done. They're rather expensive. When I say that, $200, $300 to figure out whether the levels of drugs such as opiates and other drugs, THC, are high enough to cause impairment. Again, that would be a burden of proof that you would have to prove, but OSHA is basically right now saying that they would look closely at your program if you're testing for other drugs and you aren't using reasonable levels and making sure that they could cause an injury or illness. Use test methods that are recognized as valid and reliable, and detect drugs used only shortly before the accident occurred. In other words, that's why we have to look at the levels. As we know, some drugs stay in our system for quite a long time. And I would also consult any attorney or any testing lab on what you can do to help yourself out in this area. Again, the biggest area I think is making sure that you don't have a blanket drug and alcohol policy. Instead of a blanket drug and alcohol policy, you may want to develop a policy in where we will test if we feel that the accident or injury could have resulted from the use of drugs or alcohol. Houseman Johnson has taken the opportunity to formulate some language. We use some verbiage that we received from an outside third party. We added a little twist to it, and we believe that it's something that you can use. It is not part of our presentation, but it is something that you could add to your post-incident or accident drug and alcohol policy. And if you want that and you need that, please let us know and we will get that out. We just finalized that in the last couple of days and could not make that available at the time of this presentation. But basically what we have there is post-accident injury or near-miss alcohol and drug testing policy. We provide a purpose, we provide a scope, circumstances requiring the testing, and then also enforcement and some information on what is considered acceptable testing under a policy. I guess my big word of a caution here is we can't just, according to OSHA's policy, drug test everyone just because they went to the doctor. If you have carpal tunnel or you have a bee sting, are those really, did that really happen because we were under the influence? Could that reasonably be a reason for that accident? And in most cases, you'd probably have to honestly say that probably is not, and maybe we wouldn't test for that, but we have to have a policy on how we're going to do that. So I guess the big issue here, in order to comply with OSHA's new record-keeping standard and their retaliation standards, is to make sure that we have policies that are consistent. And I think that goes back to the training and education of our workers. So in summary, don't forget that coming up in a few months, about 3 months from now, we will need to make sure that we electronically record our injuries and illnesses, make sure that you have trained your employees on how to report an injury, and make sure they understand the reporting processes. I would evaluate your policies for handling discipline, incentives, and post-accident drug testing, because I think many of those policies are probably very good, but we may need to just tweak them a little bit to meet the compliance of the intended standard here. And then finally, like I said earlier, get ready to submit. And for those of you that are over 250 employees, have a given establishment, keep in mind that starting in 2018, you will also have the responsibility to submit your 300s and your 301s or your first report of injuries. With that said, I will now open it up for any questions or comments that you may have regarding the new record-keeping standard.
All right, we received a lot of questions, so we're going to try to get to as many as we can. And if we don't get to your question, please rest assured that I will be forwarding your question to Rick after the webinar, and he will get in touch with you personally, okay? So the first question we received is, are employers notified when the website for posting 300 or 300A is available?
And the answer to that would be no. The employers will not be notified. It will be your responsibility to go on the OSHA website. They will have a link where you can send your 300 days off to, and it's really your responsibility to go out there and find that. My understanding, and I just spoke with OSHA about this in the last 2 days, is they hope to have it up probably in May. They were shooting for April, but it's probably going to be May. So I would just take a look at when that's available.
The next question is, if my organization is exempt from posting 300A, I assume we are exempt to submit electronically?
That is correct. You are correct. If you do not have to post a 300A because you're one of those employers either under 10 employees or you're in an exempt industry, then you do not have to submit your 300A. And keep in mind, it's only for employers of 20 or more employees. So you might fall in that category where you're going to keep one, but not submit it.
Our next question, when you are saying submission year 2017, submission date 7/1/2017, are you saying our 2016 information needs to be submitted by 7/1/17?
That is correct. You will be submitting your data that you have just posted on your boards in your place of employment from 2016 by July 1st or of 2017.
The next question is, can we get a copy of the handout emailed to us? And I can tell you that, yes, we will be sending you a PDF version of this PowerPoint presentation and a link to the recording in the next 24 to 48 hours. Our next question is, do you count temporary labor in your employee count when counting to 20?
That is no. You do not count employees because they do not go on your OSHA 200 log or 300 log unless you are supervising them. If they bring in their own supervisor, then they would go on their log.
Another question about, will the slides be emailed to us? I just addressed that. Can you define a legitimate business reason for drug testing?
A legitimate business reason, that's a great question because it's not real clear in the way OSHA is going to enforce it, but a legitimate reason will be that you want to provide a place that is free from the use of drugs and alcohol, which could affect other workers. There's many other reasons. When they say legitimate business reason, it means that the drugs and alcohol could have caused an injury or illness. Usually not too many illnesses, but an injury. And that's what they mean by legitimate in a way that gets in the context of the standard. You have to prove to them that your post-accident drug and alcohol testing is done because you want to provide a safe workplace. And part of a safe workplace is no alcohol and drugs, and you do post-accident drug testing. That use of drugs and alcohol could have contributed to that accident. I hope that answered that question.
To be clear, employees can be disciplined for safety violations, correct? The discrimination only would apply to the reporting.
Yes, employees can be disciplined for violating any of your safety rules as long as they're not vague. Keep in mind, they can't be vague. like maintain situational awareness. And I use that statement because that's what OSHA put in the preamble. So I thought it would be good to pass it on. And that discrimination, I guess the second part of that question is, discrimination only would apply to reporting. That is correct. That is correct.
The filing 300 electronically by July 1st is the prior year's information. We did just address that, yeah?
Yes.
Yep. That's 2016's information. How do we know if we are a drug-free workplace state?
Well, I can tell you Wisconsin is not. So we're out, I'm assuming most of you are in Wisconsin, but if you are not, there are some states, I believe Oklahoma is a drug-free workplace. I don't have a list of all of them readily available, but I'm sure that if you Googled it, you could probably find that out. Again, it has to be a drug-free workplace state, and you get some type of a reduction in your premiums if you follow certain protocols within your state. But I know Wisconsin is not one of those.
I'm going to click to the next slide just so that anybody who needs to get off this call can, but we're going to continue to answer questions for the next few minutes, okay? What if an employee falls on the ice and requires stitches? Can you test for drugs?
Yes, you can. And the reason is because that fall could have been contributed from the use of drugs or alcohol. And I think that's pretty straightforward. So yes, if they slip and fall on the ice, it could be considered drugs and alcohol a contributing cause.
Do you believe in it, if an employer made a guideline to not test for unsafe conditions and only unsafe acts, the policy would hold up to OSHA's new rule?
I guess I'm confused with the unsafe. I got to read that one again.
Hold on. Okay. Do you believe if an employer made a guideline to not test for unsafe conditions and only unsafe acts, the policy would hold up to OSHA's new rule?
That's a good question. I'd have to give that some more thought, but, 90%, 95% of unsafe conditions are usually caused because of unsafe acts. So I guess looking at that question, I would say that it would hold up to that rule if you're testing for unsafe acts, because those are what lead to the unsafe conditions. Or did I read that backwards?
I think that's right.
Yeah, I read that right.
Okay. We have a request for the post-accident policy, and if you requested that, I will make sure to send that along to your request to Rick, and he'll make sure that you get that. Is there a comprehensive listing of exempt industries?
There is under the new standard. Actually, no, it's not the exempt industries. The exempt industries are Appendix A of 1904, and it's Appendix A under the record-keeping standards. Those are all the exempt industries. You can look that up. There's only a couple industries that are exempt under Appendix A, but are included in the new electronic record-keeping standard. I think there's two to be exact. So yeah, you can find that under, I believe it's 1904 A1, if I'm correct.
In January, I received a letter that required us to complete a 2016 survey of occupational injuries and illnesses. It was from the Wisconsin State Lab of Hygiene at a U.S. Department of Labor, BLS, and I submitted online. I'm confused how that relates to the July online report.
Two different things. The old one is that's a BLS report. That's how we get our injury and illness rates. This is specifically requested by OSHA. This is a separate program that may still occur in the future. However, I think once they get the 300s, they're probably going to start sharing that information with the BLS. So they are two different things. You will still, if you are over 20 employees and you're in basically hazardous industry, or you're on that list that I provided, or that was in the PowerPoint, you will have to submit your 300 days.
Are all of the new regulations pending or currently in effect and could be repealed?
When you say all, there's a lot of them that they're looking at right now. This is definitely one that, even though it's been ruled on, there is concern in Washington, D.C. that this may get repealed. You may be talking about some of the other standards like silica. That one's also being looked at. I don't believe the walking working surfaces standard is as questionable, but those are being looked at. Those are the standards they're really looking at right now. This one and the silica standard.
I have already filled our 2016 injury data. Oh, we already did that one? All right, never mind. Please include. Is there a list of state representatives we can lobby or write in order to make a Wisconsin a drug-free workplace? Oh my God.
I do not have a list of the state representatives.
I'm sure you can just Google who our state representative is and
right, and figure out who your representative is in your area. I do not know who that is.
All right. Well, thank you everybody for your questions. I will be forwarding any requests for the policies to Rick so he can get those to you. And everybody's going to receive a copy of a link to the recording, as well as the PDF of today's presentation. And if you have further questions, please do not hesitate to reach out to Rick. I know that this is a lot of information, and a lot of it is new and strange and maybe confusing. So thank you everybody for attending, and we hope to see you next time.